Hello everyone, welcome to 𝐸𝐴𝐿𝐿. In this video, we will be discussing the most important question of Negotiable Instrument Act. So let's get started. Question number first. Who is entitled to make a complaint for the taking cognizance of the offence under section 138 of the Negotiable Instrument Act 1881? Here correct answer is option 3, that is only the holder of the cheque. Question number 2. The offence of dishonour of cheques for insufficiency etc. of funds in the account of the drawer is punishable with option first, imprisonment for a term which may extend to 1 year or with fine which may extend to the amount of cheques or with both. Option second, imprisonment for a term which may extend to 2 years or with fine which may extend to twice the amount of cheques or with both. Option third, imprisonment for a term which may extend to 6 months or with fine which may extend to 500 rupees or with both. Option fourth, imprisonment for a term which may extend to 5 years or with fine which may extend to 5,000 rupees or with both. Here correct answer is option second, that is imprisonment for a term which may extend to 2 years or with fine which may extend to twice the amount of the cheques or with both. Option second is the correct answer. Let us proceed to question number 3. Question number 3. Maximum sentence of fine which a judicial magistrate first class can impose for offence under section 138 of the Negotiable Instrument Act is option first, twice the amount of cheque, option second, 20,000, option C, 1 lakh, and option 4, 10,000. Here correct answer absolutely is the first option, that is twice the amount of the cheque. Question number 4. Court can take cognizance of any offence punishable under section 138 of the Negotiable Instrument Act. First, suo motu. Second, upon a complaint in writing made by the payee. Third, upon a police report. And option 4, none of the above. Here correct answer is option second, that is upon a complaint in writing made by the payee. Question number 5. Complaint under section 138 of the Negotiable Instrument Act must contain the following ingredients. Option first, that there is a legally enforceable debt. Option second, that the cheque was drawn from the account of bank for discharge in whole or in part of any debt or other liability which presupposes a legally enforceable debt. Third, cheque is so issued that had been returned due to insufficiency of funds, and option 4, all of the above. In question number 5, correct answer is option 4, that is all of the above. Here all the statements are correct. Question number 6. Section 138 of the Negotiable Instrument Act deals with option first, punishment for dishonour of cheque. This is the right answer. Question number 7. For the purpose of attracting provisions of section 138 of the Negotiable Instrument Act, cheque has to be presented to the bank within a period of option first, 6 months, option B, second, 15 days from the date on which it is drawn, third, 3 months from the date on which it is drawn or within the period of its validity whichever is earlier, and option 4, none of the above. In question number 7, correct answer is option third, that is 3 months from the date on which it is drawn or with the period of its validity whichever is earlier. Question number 8. Which of the following circumstances will attract the provisions of section 138 of the Negotiable Instrument Act? First, cheque dishonour due to insufficiency of funds. Second, cheque returned by the bank unpaid on the ground that the account is closed. Third, cheque returned by the bank unpaid due to stop payment of instruction by the drawer, and option 4th, in all the above circumstances. In question number 4, correct answer is option 4, in all the above circumstances. I am repeating all the options. Cheque dishonour due to insufficiency of funds. Cheque returned by the bank unpaid on the ground of the account is closed. Third, cheque returned by the bank unpaid due to stop payment instruction by the drawer, and option 4, in all the above circumstances. Question number 9. Chapter 17 containing the sections 138 to 142 was introduced in the Negotiable Instrument Act. First, Act 65 of 1988, Act 66 of 1988, Act 67 of 1988, Act 68 of 1988. In question number 9, correct answer is option 2, that is Act 66 of 1988. Question number 10. Which section of the Negotiable Instrument Act excludes the defence that the drawer had no reason to believe when he issued a cheque that it may be dishonoured on presentation of the reasons stated in section 138 of the Negotiable Instrument Act? Option first, section 138, option second, section 139, option third, section 140, and option 4, section 141. In question number 10, correct answer is option 3, that is section 140 of the Negotiable Instrument Act. Question number 11. In a prosecution under section 138 of NI Act, it shall not be a defence that the cheque does not bear his signature. Second, that the cheque was not issued for the discharge of any debt or other liability. Third, that the cheque has not been presented to the bank within a period of 6 months from the date on which it is drawn or from the period of its validity whichever is earlier. Fourth, that the drawer had no reason to believe when he issued the cheque that the cheque may be dishonoured on the presentment. Here correct answer is option 4. Question number 12. The presumption regarding dishonour of cheque on production of a bank slip is rebuttable, irrebuttable, conclusive proof, none of the above. Here correct answer is option first, that is rebuttable presumption. Question number 13. Mens rea has no place while determining the penal liability under section 138 of the Negotiable Instrument Act. This statement is absolutely correct. Therefore, option first is the right answer. Question number 14. Presumption under section 139 of the Negotiable Instrument Act 1881 is in respect of that the cheque was signed by the accused, that the cheque was dishonored by the banker, that the cheque was issued for a discharge of any debt, that the cheque was valid under banking laws. Here correct answer is option third, that is that a cheque was issued for discharge of any debt. Question number 15. Which one of the following proviso clauses of section 138 of the Negotiable Instrument Act requires notice of 15 days in case of failure of payment of cheque? Option first, clause 1, second, clause 2, clause 3, clause 4. In question number 15, correct answer is option third, that is clause 3. In section 138, clause 3 of Negotiable Instrument Act requires notice of 15 days in case of failure of payment of cheque. Question number 16. For the purpose of explanation to section 138 of the Negotiable Instrument Act 1881, debt or other liability means a part debts, a legally enforceable debt or other liability, an existing debt, a future debt. Here correct answer is option second, that is a legally enforceable debt or other liability. Question number 17. Section 138 of the Negotiable Instrument Acts provide penal provisions in case of dishonor of cheque if it is presented to the bank within a period of 3 months from the date on which it is drawn only, from the date on which payee makes demands, third from the date on which demand of payee accepted, fourth from the date on which it is drawn or within the period of its validity, whichever is earlier. In question number 17, correct answer is option 4, that is from the date on which it is drawn or within the period of its validity, whichever is earlier. Question number 18. Under Negotiable Instrument Act, how many days after service of notice of demand on drawer the cause of action arises against drawer if he fails to make payment? Option first 30 days, option second 45 days, option third 15 days, and option fourth 90 days. In question number 18, correct answer is option 3, that is 15 days is the correct answer. Question number 19. When the cause of action accrue if the cheque issued by the drawer is dishonored? Option first, on the date of receipt of information by the bank regarding the return of cheque as unpaid. Option second, on the date when the notice is issued by the payee to the drawer. Option third, on the date drawer of cheque fails to make payment of cheque amount to pay within 15 days from the receipt of the demand notice. And option fourth, none of the above. In question number 19, correct answer is option third, that is on the date drawer of cheque fails to make payment of cheque amount to pay within 15 days from the receipt of the demand notice. Question number 20. Written complaint should be made to the court from date of causes of action within a period of. Correct answer is option first, that is 30 days. Question number 21. Which section of the Negotiable Instrument Act 1881 provides that where a person is nominated as a director of a company by virtue of his holding any office or employment in the central government or the state government, as the case may be, he shall not be held liable for the offence under section 138 of the Negotiable Instrument Act committed by a company? Option first, proviso 1 to section 141 subsection 1, proviso 2 of section 141 subsection 1, and option third, proviso subsection 2 of section 141, and option fourth, none of the above. Here in question number 21, the correct answer is option first, that is proviso 1 of section 141 subsection 1 is the correct answer. Question number 22. A demand notice in writing has to be given to the drawer by the payee under section 138 of the Negotiable Instrument Act 1881 after receiving intimation from the bank of dishonor of cheque within a period of. Correct answer here is option second, that is 30 days. Question number 23. For the purpose of section 141 of Negotiable Instrument Act, a company does not mean or include a body corporate, a firm, a proprietary concern, an association of individuals. Here correct answer is option 3. A proprietary concern is not included in the company. Question number 24. If a person committing an offence under section 138 of the Negotiable Instrument Act 1881 is a company, the following shall be deemed to be guilty of the offence. Option first, a person who at the time of the offence was committed was in charge of and was responsible for the conduct of the business of the company and not the company. The company in its name, the director of the company nominated by the central government. And option 4, the person in charge of and responsible for the conduct of the business of the company as well as company. Here in question number 24, correct answer is option 4, that is a person in charge of and responsible for the conduct of the business of the company as well as company. Question number 25. Who as the drawer of a cheque can be prosecuted for non-payment of the cheque due to insufficient funds under section 138 of the Negotiable Instrument Act? Option first, only a human being, second, only a body corporate, third, only a firm, and option 4, all of these. Here obviously the correct answer is option 4, that is all of the above. Question number 26. For the purpose of section 141 of the Negotiable Instrument Act 1881, company means option A, a body corporate, a firm, other association of individuals, all of the above. Correct answer is option 4, that is all of the above. Question number 27. Section 141 of the Negotiable Instrument Act deals with the offence caused by the government servants, individual and companies both, individual alone, companies. Correct answer here is option 4, that is companies. Question number 28. If a prosecution for an offence under section 138, the fact that drawer had no reason to believe when he issued the cheque that the cheque may be dishonoured or on presentment. Option first, shall be a defence. Option second, shall not be a defence. Option third, shall be sufficient to dislodge the presumption under section 139. And option fourth, shall be a ground to refuse the issuance of process. Here correct answer is option second, that is shall not be a defence. Question number 29. Every trial under section 143 of the Negotiable Instrument Act shall be conducted as expeditiously as possible and an endeavour shall be made to conclude the trial. Option A, within 3 months from the date of filing of the complaint. Option second, within 1 month from the date of filing of the complaint. Option third, within 6 months from the date of filing of the complaint. And option 4, within 1 year from the date of filing of the complaint. In question number 29, correct answer is option third, that is within 6 months from the date of the filing of the complaint. Question number 30. The maximum amount which may be awarded as an interim compensation under section 143A of the Negotiable Instrument Act 1881 is 10% of the amount of cheque, 20% of the amount of cheque, 30% of the amount of cheque, 40% of the amount of cheque. Here correct answer is option second, that is 20% of the amount of cheque. Question number 31. Section 143A of the Negotiable Instrument Act 1881 was inserted by Negotiable Instrument Amendment Act 2018, Negotiable Instrument Amendment Act 2013, Negotiable Instrument Act 2015, Negotiable Instrument Amendment Act 2016. Correct answer is option first, that is Negotiable Instrument Amendment Act 2018. Question number 32. How much period prescribed for payment of interim compensation under Negotiable Instrument Act 1881? Here correct answer is option 3, that is 60 days. Question number 33. Provision of interim relief under Negotiable Instrument Act is mandatory, directory, binding, none of the above. Here correct answer is option second, that is directory. Question number 34. When the notice of dishonour of cheque contemplated under section 138 subsection 2 of the Negotiable Instrument Act issued by the payee/holder in due course has been received by the drawer on the date, then as per section 142 cognizance of offence can be taken if complaint for the offence of the dishonour has been made within 15 days, 13 days, 45 days, 60 days. In question number 34 correct answer is option second, that is 30 days. Question number 35. The Negotiable Instrument Amendment Act 2018 makes it possible for a court trying an offence related to cheque bouncing to direct the drawer, person who writes the cheque, to pay interim compensation to the complainant under certain circumstances. The interim compensation will not exceed dash of the cheque amount. Here correct answer is option 4, that is 20% of the cheque amount. Question number 36. Power of the court to try cases summarily given under section 143, 142, 138, 139. Here correct answer is option first, that is section 143. Question number 37. Which one of the following sections of the Negotiable Instrument Act empowers judicial magistrate of the first class or metropolitan magistrate to try the offence relating to dishonour of cheque for insufficiency, etc.? Here correct answer is option first, that is section 143 subsection 1. Question number 38. The cognizance of offence under section 138 of the Negotiable Instrument Act to be taken by the judicial magistrate first class having territorial jurisdiction at the option first, place of the issuance of the cheque, second, place of the delivery of the statutory notice, third, place when complainant chooses to present the cheque for encashment of by bank, option 4, place where the cheque is dishonoured by the bank on which it is drawn. Here correct answer is option 4, that is place where the cheque is dishonoured by the bank on which it is drawn. Question number 39. The delay in filing a complaint under section 138 of the Negotiable Instrument Act 1881 can be condoned. Option first, under section 5 of the Indelimitation Act. Option second, under section 138 of the Negotiable Instrument Act. Option third, under section 142 of the Negotiable Instruments Act. And option fourth, under section 143 of the Negotiable Instrument Act 1881. Here correct answer is option third, that is under section 142 of the Negotiable Instrument Act 1881. Question number 40. The provision that no court inferior that of the metropolitan magistrate or a judicial magistrate of the first class shall try the offence punishable under section 138 exists under. Here correct answer is option 3rd, that is clause 3 of the section 142. Question number 41. Which one of the following court is empowered to try the offence relating to dishonor of cheque for insufficiency etc. under the Negotiable Instrument Act 1881? Here correct answer is option 2nd, that is Judicial Magistrate of the first class. Question number 42. In which court the complainant has to file an appeal against the order of acquittal under section 138 of the Negotiable Instrument Act? Option 1st, Court of Session, 2nd, High Court, 3rd, Chief Judicial Magistrate, 4th, either Court of Session or High Court. In question number 42, correct answer is option 1st, that is Court of Session. Question number 43. Section 142A of the Negotiable Instrument Act 1881 was inserted by, correct answer is option 1st only, that is Act 26 of 2015, Section 4, with effect from 15/6/2015. Question number 44. The maximum amount of fine which can be imposed under section 138 of the Negotiable Instrument Act is option 1st 10,000 rupees, 2nd 1 lakh rupees, 3rd equal to the cheque's amount, and option 4 twice to the cheque amount. Here correct answer is option 4, that is twice of the cheque's amount. Question number 45. Can magistrate order an investigation on the allegation of an offence under section 138 of the Negotiable Instrument Act? Option 1st yes, 2nd no, 3rd depends, 4th none of the above. Here correct answer is option 2nd, that is no. Question number 46. Amendment in Negotiable Instrument Act 1881 made in 1988 has introduced an important provisions relating to option 1st easy negotiability, 2nd dishonor of cheque, 3rd bank draft, and option 4th privileges of holder in due course. In question number 46, correct answer is option 2nd, that is dishonor of cheque. Question number 47. Match list first with list second and select the correct answer by using the codes given below. Here in list first option is cognizance of offences. Correct answer here is section 142, offences by companies and firms. Here correct answer is section 141. Dishonor of cheque for the insufficiency of funds. Correct answer is section 138. Power of court to try cases summarily. Correct answer here is section 143. By going through these matches, the correct option where will be option 2nd. Question number 48. What are the defences available against proceedings under section 138 of the Negotiable Instrument Act? First, absence of a legally enforceable debt or liability. Second, absence of a legal notice of 15 days. Option 3rd, lack of jurisdiction, and option 4, all of the above. In question number 48, correct answer is option 4, that is all of the above. Question number 49. Match list with list second and select the correct answer by using the codes given below. In list 1, the provisions is given, and in list 2nd, sections of Negotiable Act is provided. Now let us proceed with the option first. Cognizance of offences. It is provided in section 142. Therefore, option 4 will be the right answer. Power of court to try cases summarily. Here correct answer is section 143. Defences which may not be allowed in any prosecution under section 138. Here correct answer is 140. And the last option, presumption in favor of holder. It is provided in section 139. Therefore, the correct code for this will be option first. Question number 50. A complaint against an offence under section 138 of the Negotiable Instrument Act is must be in writing, may be in oral or in writing, must be in writing supported by an affidavit, may be oral statement before magistrate. Here correct answer is option first, that is must be in writing. Question number 51. Cheque issues under the same transaction dishonored one complaint in respect of all cheque is maintainable, not maintainable, only when a single notice is sent, none of the above. Here correct answer is option first, that is maintainable. Question number 52. Which section provides that offence under Negotiable Instrument Act are compoundable? Here correct answer is option 3rd, that is section 147 provides that the offences under Negotiable Instrument Act are compoundable. As per section 147 of the Negotiable Instrument Act, every offence punishable under the Act is option 1st compoundable, option 2nd non-compoundable, option 3rd cognizable, option 4 both 2 and 3. Here correct answer is option 1st, that is compoundable. As per section 147 of the Negotiable Instrument Act, every offence punishable under this Act is compoundable. Question number 54. In trial an offence under section 138 of the Negotiable Instrument Act 1881, the provisions of section 262 or 265 of the CRPC shall apply, shall not apply, sometimes shall apply, none of the above. Here correct answer is option 1, that is shall apply. Question number 55. Offence under Negotiable Instrument Act are cognizable and compoundable. non-cognizable and compoundable, cognizable and non-compoundable, non-cognizable and non-compoundable. Here correct answer is option second, that is non-cognizable and compoundable. Offences under the Negotiable Instrument Act are non-cognizable and compoundable. Question number 56. An offence under section 138 of the Negotiable Instrument Act was tried summarily, but the court imposed on the accused a sentence of imprisonment for 1 year. The sentence is legal, only irregular, only improper, irregular. Here correct answer is option first, that is legal. Question number 57. Which of the following sections are amended by the Negotiable Instrument Amendment Ordinance 2015? Correct answer here is option 3, that is 142, section 142. Question number 58. Which of the following new sections have been introduced by the Negotiable Instrument Amendment Ordinance 2015? Here correct answer is option 3, that is section 142A. Question number 59. In which of the following judgments the Supreme Court held that only those courts within whose territorial limits the drawing bank is situated would have the jurisdiction to try cases for the offence under section 138 of the Negotiable Instrument Act 1881? Here correct answer is option second, that is Dashrath Roop Singh Rathod versus State of Maharashtra and another 2014. Question number 60. In a recent case, Supreme Court has held that where the cheque amount with interest and a cost as assessed by the court is paid by a specified date, the court entitled to close the proceeding in exercise of its power under section 143 of the Act, read with section 258 of CRPC, the case is, here correct answer is option first, that is Messrs. Meters and Instruments Private Limited and another versus Kanchan Mehta. Question number 61. Supreme Court has laid down certain directions to criminal courts for speedy and expeditious disposal of cases falling under section 138 of the Negotiable Instrument Act 1881 in the case of. Correct answer here is option first only, that is Indian Bank Association and others versus Union of India. Question number 62. In which of the following cases the Supreme Court issued guidelines regarding compounding of cheque cases in different stages including trial, appeal, revision, etc.? Correct answer here is option third, that is Damodar S. Prabhu versus Syed Babalal. Question number 63. If the applications for compounding is made before the session court, such compounding may be allowed on the condition that the accused pays dash percentage of the cheque amount by way of cost. Here correct answer is option third, that is 20%. Question number 64. If the application for compounding is made before the Supreme Court, such compounding may be allowed on the dash percentage of cheque amount by way of cost. Here correct answer is option third only, that is 20%. Question number 65. When the rate of interest is specified in instrument, interest of the amount due shall be calculated at the rate of. Correct answer here is option 4, that is 18%. Question number 66. Amendment in section 148 of the Negotiable Instrument Act 1881 effective from 1st September 2019 shall have a retrospective effect is held in the case of. Correct answer here is option first only, that is Surinder Singh Deshawal versus Virendra Gandhi 2019. Question number 67. An offence under section 138 of the Negotiable Instrument Act is compoundable. Option first, if the cheque amount is up to rupees 1 lakh. Second, if the cheque amount is up to rupees 5 lakh. Third, if the cheque amount is up to rupees 10 lakh. And option 4, cheque of any amount. Here correct answer is option 4, that is cheque of any amount. This was the last and the final question with the Negotiable Instrument Act. Thank you so much. Thank you for watching. Please like, share and subscribe our channel.